life. The bad news is it's about the Freedom of Information Act, which is not exciting at all, but I'm going to give you a quick briefer. It's called Freedom of Information Act in a nutshell, and I'm always happy to answer any questions after the fact or during, so feel free to stop me, okay? So away we go. The basics of the Freedom of Information Act: it covers public meetings, and it also covers our public documents. So, if you look at the statute, it's 3410, is the basic the statute itself. It says here, the purpose of the Freedom of Information Act is to provide our service to show that we are performing our business in an open and public manner, so that citizens shall be advised of the performance of public officials and of the decisions that are reached in public activity and in the formulation of public policy. That means everything you guys say, write, and do as it relates to the Isle of Palms and the government business, the business of government, is open to the public. So, how does this apply to you in a practical perspective? Let's start with meetings. And Charlie did cover a good portion of that, but just remember that all of our meetings for the Isle of Palms are to be open, and the public is supposed to be duly noticed. And the convening of a quorum is considered a meeting, which has to be duly noticed to the public. I thought Charlie did a really good job covering that. So just watch out for these situations that we've already talked about. That is, no chance meetings where you're discussing business in a forum of a committee or of a council. And also, here's the one kicker here with the group chats and things like that. So we had a case, gosh, how long has it been now? The Brock case. Judge Nicholson ruled in a trial, lower court order, that, you know, group emails and group texts, since the technology was so new back in the day, it's hard to say that that is a meeting, but it's all about the proximity of time. So if you guys are in a group chat, like on Facebook or Snapchat, and you're writing back and forth within seconds, that is considered a public meeting or a group discussion that could qualify as a public meeting. So just be very aware of that, especially group text messages. I've been seeing a lot of that. Be careful to avoid group text messages and responding to each other in preparation for a meeting, especially if it's all of you. Okay, there are certain things that we can conduct outside of the public eye, and those qualify under something called an executive session. I'm sure you all have probably heard this in one form or fashion, and poor Mr. Pounds has already probably heard half of this. But so certain topics that are that can be heard or discussed out of the public eye under executive session. Anything just about employment, personnel matters, any contract negotiations, any legal advice regarding pending, threatened, or potential litigation. Those are generally, if you have legal questions of me regarding situations like that, we would usually discuss those in an executive session. Security personnel or devices. If Chief Credette wants to talk about safety protocols for an active shooter alert or anything like that, we would do that behind closed doors for obvious reasons. We don't want people to know what our safety procedures are. Any allegations or investigative proceeding regarding criminal misconduct, that is also something that would be behind closed doors in an executive session. Those are the ones that would generally apply to you guys. Not the criminal conduct, just those topics. Okay, another issue when it comes to FOIA that's litigated quite a lot is this issue of announcing the purpose of going into executive session. And this is for committees as well as council. Always make sure to read the specific purpose on the agenda, because Desiree actually does a really nice job of making sure it's detailed enough so the public knows what you're going behind closed doors to discuss. And you always want to announce it with specificity. That is the key word there. And so, just a case in point, quality towing is a case out of 2001, Supreme Court decision, or the Court of Appeals, it doesn't really matter, but it's a court decision that we follow regularly. And that is, in that particular case, the agenda item just said towing contractual recommendation. The announcement from the mayor going into the meeting, or the executive session, was that this matter will be discussed in executive session. The court said that's not enough. You can't just, I love what actually they wrote here. FOIA is not satisfied merely because citizens have some idea of the public purpose of the basis for your discussion. So just make sure that you announce with specificity what you're going in to talk about. And always remember, too, when you come out of an executive session, no votes are supposed to be taken. No straw poll is supposed to be taken in an executive session. And so when you come out of an executive session, one of the first things the chair needs to mention is that no votes were taken, no action was taken in executive session. So always remember that in your committee meetings as well.
Julia, the
Yes, sir.
executive session has to be pre-planned on the agenda, and there's no spur of the moment.
Well, you know, there are, the Supreme Court's been kind of squirrely about that because they want you to always have notice on the agenda, but there are issues that come up that would require you guys to go into executive session. Let's say there's an item on the agenda where someone has a legal question, or could this potentially get us in a lawsuit? I would have to say, we need to go back in order to hear my answer. So in situations like that, yes, it's perfectly appropriate for you guys to go into executive session to get legal advice on that particular matter.
Don't we do that sometimes in committee meetings also?
Mm-hmm.
Yeah, that happens quite often, right?
What, spur of the moment?
Spur of the moment
Executive
executive session.
Well,
Not really.
Not really, no. I mean, whenever you all receive legal advice, the city attorney has to be present because she's the only one that could provide legal advice. But yeah, the reason why we include the executive session language on every agenda is to protect from that. In case those events happen and you all need to get into executive session to discuss any of the items there.
Right.
That allow you to be behind closed doors.
Yeah, and just to have that item actually on the bottom of all of our agendas that we might go into executive session if it's necessary. That's just letting the public know that there is a chance that we could do that. Yes, sir.
And what gave birth to this FOIA? I know lawsuit. I mean, what was it? Just around transparency? I mean, what birthed
The quality towing one? This one right here?
What birthed the whole FOIA app?
That's probably a nationwide transparency.
Just curious.
I don't have the answer to that question, but I can certainly find out for you.
Julia, real quick.
Yes, sir.
Do I have to say, in accordance with section 30-4-70A2 to receive, do I have to go into all those numbers every time? Better to?
Yeah, I would suggest we just read off exactly.
We always have, but
Mhm.
just
Yeah.
making sure.
Yes, sir.
Thank you.
We put that on the agenda for a reason. Okay, so I do have a little section in here about recent amendments to the FOIA lawsuit. I think Charlie covered a lot of this about having to have an agenda, having to post the agenda. No items added within 24 hours. He talked about amending the agenda in certain circumstances. An exigency, I love that word. An urgent need or circumstance, that would be the basis for amending the agenda to include something that's final. All right.
Wait, I have a question.
Yes, ma'am.
I would like to know exactly who we are notifying for notifying the public and the press. What exactly are we doing?
Well, we have to post the agenda in a public place, so we post a paper copy at City Hall. It's also posted online, and we give notice to the paper every week of the meetings that we're conducting for that week, and provide a link to where the agendas are posted.
When you say the paper, the posting
Correct.
not necessarily Island Eye and the Moultrie News?
You know, I believe our code specifies a newspaper where it has to go. So yeah, we typically post all the agendas in the city calendar, the agendas and minutes page. We often do it on Facebook as well. We have link the agenda there, and also notify the closing courier every week.
I would say, as a matter of course, we should be notifying Island Eye and Moultrie News. I think they keep up with it anyways, but I think that they are actually more the people that come to our meetings, and I think it should be also sent out to the TV stations. Would you not have like a mass agenda? At the very least, I think Island Eye.
I know that the TV channels are constantly looking at it. They I get questions on agenda items all the time. We don't typically send it directly to them. It's just posted available online and but the Island Eye, I think that's a great idea. There's no problem.
But they only publish twice. So I mean, in order to hit their cycle to get on the paper.
Yeah.
And I'm actually thinking about the
Yes.
coverage of.
And now that I remember, we do send them a schedule at the beginning of the year, so they do post and have the calendar schedule. In the past, it's been a little challenging because the committees would change changed their dates. I think this year will be the second year where you all maintain the same meeting schedule, so that helps for consistency purposes. But yeah, we do advertise with them the meeting, at least the council meeting. I have to go back and double check if we include committee meetings as well.
Mayor, would it be appropriate that Ms. Copeland may be able to expand? Another thing that I see, and this is particularly for the new folks, executive sessions, keeping that matter in executive session. We see across the state challenges with councils where they will have conversations of what took place in executive session. I would particularly, if you remember when I mentioned staying in your lane and ways that you could be potentially liable personally, particularly with personnel matters, we see unfortunately council members speaking of some of those personnel matters outside of meetings.
Oh goodness, I mean, there's a case out of Richland right now where a council member was texting the administrator what to demand to terminate the contract while in executive session.
So you may not have insurance coverage
Yeah.
if you do some of these things.
Yes, Charlie's expression, stay in your lane. Always remember that, stay in your lane. Thank you, Charlie. All right. So now let's shift from meetings to public documents and how this is now going to affect your life. Welcome to the public sector. So first of all, Public Records Act. This is the state statute, which describes as a public record all books, papers, maps, photographs, cards, tapes, recordings, or other documentary materials, regardless of physical form or characteristics, prepared, owned, used, in the possession of, or retained by a public body. That's our state law as it relates to public records. We also have the Uniform Electronic Transaction Act and state code as well, which describes its electronic records management guidelines. And it also has a similar description of government record, which is anything you create, use, and manage electronically in your daily work, emails, published web pages, databases, anything related to your work for the Isle of Palms. And let me tell you why. Well, one thing, with our emails, okay, our IT department, if you're using the City of Isle of Palms, the IOP.net email, when you send an email, it's trapped by our firewall, correct? So it's
We
automatically
have a server that maintains all of that.
Right, okay. But one thing I will tell you, text messages. We have no way to document and keep your text messages. So if you are sending text messages that are city related on your city phone, do not delete them, because those could be subject to FOIA. Those could also be subject to discovery and litigation. If someone sends me a subpoena asking for all of your text messages related to phase 3 drainage, I'm going to have to come to you and ask for your text messages. So do not delete those. Also, if you're using your personal phone, if some citizen sends you a text message on your personal phone, you need to tell them, use my city phone, do not use my personal phone, because that also will open you up to a FOIA request or a discovery request. So always keep that in mind. Same thing with your emails. So I'll tell you right now, text messages, they're fair game for FOIA and discovery and litigation. So keep that in mind when you're operating with your personal cell phone, especially with city business. Always try to keep that to your city cell phone.
Well, they don't have a city cell phone. They do have a city issued iPad.
Okay.
That they could send and receive text messages, so it's the same thing.
Okay, yeah, just try very hard to separate those two things.
Julia,
Yes, sir.
real quickly, every time I answer an email, I always copy Desiree. I want a paper trail with anything and everything.
Or Desiree.
Or Desiree.
I mean, that's a lot of emails.
But I think it's just a good practice to do, because that way she knows what's being said.
I think it's a great practice, especially considering, you know, a lot of the times you two are working together to solve these problems too, so keep her in the loop too. But yeah, for documenting purposes, that's an excellent idea. And also, if you guys, again, just like with text messages, if you get emails on your personal accounts, you get emails on Facebook Messenger, anything like that, the best course of action I would suggest for any of you is to say, please send this to my IOP.net address, because otherwise, and I will attest from experience, that I've had to friend council members on Facebook so I can look through 2 years of their timeline. As much as I love you all, I don't want to be friends with you on Facebook and go through all of your personal photos. So it does happen, folks. Yes, ma'am.
Well, I will, if I get a personal email on city business, I will respond to it and CC my city email.
That's great too. As long as we can pull it by just pulling the server, that's great. What happens typically, and this is again from experience, we'll do a document dump, 4,000 emails, and they'll pile through it, and they'll find one email that shows you forwarding that email to your personal address, and then they'll say, we want all emails from this personal email address. So,
I'm talking about in the reverse.
okay, but yeah, just be aware. I think that's an excellent idea, as long as you're documenting everything and saving it on your server. If you do have any email communication on your personal email address, don't delete them. Put them in a specific folder about a project. You know, you can label it a project or just label it the city folder. That way, if you need to have ready access to them in case I come to you and say, I need all emails related to this project, you have ready access to it and you can get it to me. Yes, sir?
I don't use emails for any of this stuff. I do everything on a telephone call.
You're a rare breed, sir.
I know, but I'm really
I love
afraid
that.
of this stuff. But I don't really have a problem then, right?
Well,
I mean,
Well, I'll take
citizens,
that.
citizens comment, they write me and they say, well, I want you to respond to email. I'll talk to you on the phone.
well, that's old school. That's old
Anytime.
school politics.
But
right there.
they say, well, you know, I want to email, and I'm like, well, this is the reason, because you got a thread on me.
Right.
So, but I'm not doing anything illegal by doing that.
No, you're not. And I tell you, there's nothing worse than having to flip through 3 weeks of email communication with seven different people on it, and trying to keep track of where it started.
So you're talking about, like CCing Desiree to document, but really you don't, that's not necessary if it's in the system.
Correct.
As long as you don't delete anything from your device. We do have a way of getting to that information, but you shouldn't be, regardless of the server, the backups, you shouldn't be deleting any city
Because
email.
If all of us always copied you on that, that would be a little.
Desiree would never go home. She's sitting here.
She doesn't.
I'm about to say you go home.
Sometimes.
Okay, and also, if you have any questions, always ask Desiree. If she can't find the answer, she'll ask me, okay? So we're always open for questions. Don't you dare CC me. All right, let's shift now. Does anybody have any questions about public documents and your responsibility now going forward with that? Okay, let's talk about something equally exciting, which is the Ethics Act of 1991. So the individuals covered under the Ethics Act: public officials, public members, and public employees. You guys, must be public officials, public employees here as well. So should all love to hear this topic for sure. But the one thing I'm going to focus on, Charlie did mention financial disclosure responsibilities. I didn't prepare to talk about that, but if you guys have any question about, do I need to report this? You know, I was given a ticket to something. Courtney Laster, excuse me, is the general counsel for the Ethics Commission, and she will answer her phone, and she will get you an informal opinion if you have an informal, if you have a need for an informal opinion. I mean, she's very quick in her turnaround and her responses. You can email her, you can call her. She's really helpful, actually. In fact, I stole some of these slides from her. So let's start with the use of office for financial gain. Doesn't that sound exciting? So no public servant may knowingly, and I underline knowingly because that's a big definition that they always focus on, use his financial, or excuse me, official position to obtain an economic interest for himself, a family member, an individual with whom he is associated, that's kind of broad, or a business with which he is associated. Okay, and then we break down I broke down the definitions here for you. So family member, obvious, spouse, parents, in-laws, siblings, also in-laws, child, grandparent, or grandchild. So that's family member, that's pretty easy. Immediate family, child residing in your house. spouse, individual claimed as a dependent for income tax purposes, or the spouse of a public servant. Business. It's a corporation, partnership, proprietorship, firm, enterprise, franchise, an association, organization, or a self-employed individual. That includes nonprofits and other charitable organizations. Now, this is the interesting one. Business with which he is associated. Business with which public servant, immediate family member is a director, officer, owner, employee, compensated agent, or holder of a certain amount of stock. And then finally, an individual with which he is associated. An individual with whom the person or a member of his immediate family mutually has interest in any business of which the person or a member of his immediate family is a director, officer, owner, employee, compensated agent, or a holder of certain stock. So the statute breaks it down for you. So if you ever have any question about your association with any particular action item on an agenda, you can always refer to these sections to find out if you have any kind of connection that might draw you to recuse yourself.
For me, can I call that thing for financial loss? Be a loss.
You talking about your house?
No.
Okay, so economic interest. Let's define that in the statute. It is an interest distinct from that of the general public in a purchase, sale, lease, contract, option, or other transaction or arrangement involving property or services in which you may gain a public benefit of more than, you ready for this? $50. Low threshold there, y'all. Now, there is one big exception that's going to be applicable to you guys. Is if your interest is incidental, like if you live in a neighborhood, you're changing the zoning of the entire neighborhood. That's incidental, or qualify as a large class exception. Those are situations where you would not need to recuse yourself. Now, here's our statute here. No public service may make, participate in making, or in any way attempt to use his position to influence a governmental decision in which he, a family member, or an individual business with whom he is associated has an economic interest. So that means, I mean, that sounds pretty broad, right? Not only can you vote, you can't vote, but you can't participate in the discussion. I mean, I would go so far as to say you can't have any conversations prior to the vote or the discussion. Phone calls, attempting to influence in any way. Okay, so let's say you come across a situation where, yeah, I do have a potential financial or economic interest in this vote. You need to prepare a written statement. And we do have a form. Desiree has the form. It's pretty simple. You just write that you're going to be recusing yourself in this particular situation. Desiree will give the statement to the chief officer at the meeting, and they will announce that you are going to be recusing yourself. And in that situation, you would just stand up from the dais, and would we leave the room or do we just sit in the house? What did we decide on this one?
I think Charlie would advise
To leave the room?
Leave the room, yeah.
Some of you can be menacing, just sitting in the room. Okay? So do you guys have any questions about the recusal? Okay. Pretty straightforward. And again, Courtney Lassner, she's amazing. She's very responsive. All right, I'm going to talk real quickly about the Tort Claims Act, which provides some coverage for us as a municipal body. So when we're making decisions, like if we're voting on an ordinance, or we're voting to make a zoning decision, and someone gets really upset with us, and they sue the municipality, this provides, one, a ceiling of cover, or a ceiling of,
Liability.
thank you. But it also provides exemptions for specific acts. So you can see here, there's the statutory reference section there. But the General Assembly recognized government's unique roles and obligations in society. The Act specifically exempts public entities from liability resulting from certain actions like legislative, judicial, or quasi-judicial action or inaction, choosing not to adopt an ordinance, choosing not to zone a piece of property that way. And this is where Charlie's staying in your lane business really takes hold. If you are staying within your scope of duties and you are acting as a council during a meeting and voting on a particular topic, that is qualified as within your legislative duties, within legislative action, which would qualify you for coverage of the Tort Claims Act. But be careful, because there's always a chance that you could get outside of the, Tom Ellenberg was a municipal lawyer for the city of Myrtle Beach for like almost 40 years. And he was great. great. It kind of reminds me of Andy Griffith, but he always talked about the circle of trust. As long as you're staying within your lane, you are within the circle of trust. The moment you step out, you're heading for a little world of trouble here. Defamation of character. If you're going out there and intentionally defaming someone, social media or in public, you're potentially walking out of the protections of the Tort Claims Act. And any intentional act outside the scope of your duties. I'll give you an example. Picking up the phone and threatening a citizen in order to get them to break a contract. That could potentially get you away from getting coverage under the Tort Claims Act. Also, another thing I want to talk to you about is more case law driven. It's called legislative immunity. Again, in a situation where someone's unhappy with your decision and they sue the Isle of Palms, but they also name you all personally, which we have gotten into situations like that in other municipalities, state law provides for legislative immunity, where as long as you are staying within your lane, you could be completely booted out of the lawsuit, and we've had very favorable decisions in that respect. But the public good is undermined, and I love this case law out of Bogan. The public good is undermined by any restriction placed on the legislator's ability to exercise discretion, including fear of personal liability. I think that's very true. I mean, you guys are putting yourselves in these situations where there could be some very angry members of the public out here that don't want you to make these decisions. This type of immunity is invaluable in that situation. All right, so with that said, you guys have any questions for me?
Really good.
Or have I completely put you all to sleep?
No.
Are y'all sure you still want to serve? Too late.
Too late, you're all part of this crazy crew.
I like Charlie's thing, he got elected, now what?
That's great.
What we've been saying every day, right?
Right.
Yes.
Okay, moving on.
Well, if there are no questions about any of the topics here that you would prefer to cover under executive session, we only have one section left on the agenda for executive session related to another topic.
That leads us into accordance with section 30-47A2 to receive legal advice regarding and consideration of legal options for the city related to the lease with Morgan Creek Grill. Do I hear a motion to go into executive session?
So moved.
Second? Okay. Any discussion? All those in favor, signify by saying aye.
Aye.
Any nays? Ayes have it. Thank y'all for coming. Feel free to come back and listen to it afterwards.